Hey Ron.
Hey, how you
Good to
doing?
see you.
Doing good.
Got Ron Reardon here from Patents and More. Ron, I was just reading a little bit about you. I've known you for quite a while, and certainly we work together on projects in terms of us working with you to send people your way to
Right.
make sure that indeed they get the right advice and attention. But you're the president of the National Association of Patent Practitioners.
That's correct.
Try saying that one 5 times straight. And of course, the president of the United Inventors Association. So we're certainly pleased to have you here, and you're the expert. So we want to ask you a bunch of questions to help inventors understand how important it is to go through the process of making sure that their patent that they're going to file is indeed done right.
Correct.
That they're not infringing on other people's ideas. And this is the foundation of the house, and as far as I'm concerned, getting this right is the stepping stone to doing everything with your invention. So tell us about Patents and More, what's going on in the patent world, so to speak, these days.
Okay. Well, of course, patent law changes almost every week as they have different court cases and everything. But with Patents and More, I started the business after I retired from Bell South in 2002. I currently got over 260 clients, so things have been going very, very well. And Patents and More, patents is my focus, okay? But then the more part is I actually connect inventors with the resources that they need that I don't do. So, if they needed your services, I would direct them your way. If they actually need trademark work, I would send them to a trademark attorney. Because patent agents, while they can do patents, they can't do trademarks. And so if they needed prototyping, I would send them to Slingshot and things like that.
Now, Ron, one of the most common questions people ask, and you know this is coming,
Yeah.
should I use a patent agent or should I use a patent attorney? And I think people are certainly confused as to the advantages, or I don't want to say disadvantages, of using one or the other, but why would somebody come to you, and then why would somebody need a patent attorney?
Okay. Well, let's first go with what it takes to become either a patent agent or a patent attorney.
Okay.
You first have to have a science degree. I was a physics major, so both patent agents and attorneys have to have a science degree. Then they both have to pass exactly the same patent bar. Okay? It's something like a 6-hour test, 3 hours in the morning, 3 hours in the afternoon. The hardest test I've ever taken. The pass rate goes between 19% and 51%, so it's a very difficult test to pass. And then you have to be of good moral character. They actually post your name on the internet and says if anybody knows that this guy's a mass murderer or anything like that,
Nice.
tell us now.
Okay.
And then you're actually allowed to practice patent law with the patent office. Most people don't realize that the only place in the United States where you can practice law and not be an attorney is with the patent office, because it's federal law, and they say that you don't have to be a state attorney in order to represent clients with the patent
Really?
office.
That's interesting.
Yeah. And in general, patent agents are less expensive than patent attorneys. Of course, there's always exceptions to that. And also in general, a patent attorney generally is really focused on law, and they don't know very much about marketing or any other thing other than law. And so with a patent agent, usually they have connections like I do with folks like yourself that do non-patent kind of stuff and can actually connect the inventors with other things. And generally, the patent agent has got less overhead, so they're less expensive. But the quality is still the same as with a patent attorney. So the decision of patent agent or patent attorney depends on what you want done as an inventor. If you want trademark work done, you're going to need a patent attorney to do that. Copyright work, the same thing. While a patent agent can give a patentability opinion, as can a patent attorney, a patent agent can't give an infringement opinion, can't give a freedom to operate opinion, can't do litigation. So there's everything that can be done with state law, you need an attorney for. But if you're looking at somebody that can can do a really good patent search, craft a really good patent, and represent you well with the patent office, a patent agent can do everything that a patent attorney can do with the patent office.
So the only exception would be if, for example, and I'm thinking of all the inventors out there, I create a product, I don't do a patent search, I just say, I'm going to say, damn the world, I'm going out there and I'm taking this product without even checking, and I'm going to develop it. I sell it to a big retailer, and all of a sudden I get that nasty cease and desist letter in the mail saying, Jim, you've got to stop